clear up some of the muddy issues. Joining me here in New York is defense attorney and CNN legal analyst Mark Aragos, and from Washington we welcome Lori Windham, she's senior counsel at the Becket Fund for Religious Liberty. All right, so Lori, I want to begin with you, and you'll have to correct me where I'm wrong. I'm piecing together a lot of things very last minute as Asa Hutchinson sort of threw everything for a loop this morning. But first and foremost, the Becket Fund, as I understand it, has been trying to sort of lay out the blueprints for those who are very concerned about the onslaught of gay marriage and how to sort of navigate around things when that issue threatens what people believe are their religious beliefs and how they can continue to effectuate their religious beliefs and not be encroached upon by these new government freedoms to gays and lesbians. First of all, is that right?
What we have done is we've gathered a bunch of scholars who have differing views on gay marriage and differing views on the law to look at what are the conflicts going to be, where are they going to come up, and what can be done about them. And what you've seen in many states is this has been accomplished not through state RFRAs, which is what we're talking about today, but it's actually been accomplished when state legislatures enact gay marriage laws, where they have also enacted them almost always with some sort of religious freedom protection, especially for churches and religious organizations.
It gets very complicated for the average viewer out there who hears one narrative versus another narrative in a bumper sticker form. Effectively, a lot of people are saying, and this is what Mike Pence was so angry about, is that his law has been grossly mischaracterized as a license to discriminate. But my question to you is, why shouldn't people believe that when he lines up a bunch of lobbyists who are vehemently opposed to gay marriage and puts them there for the photo op while he signs the bill, and the clear byproduct, or maybe it wasn't intended to be a byproduct but an actual product of the bill, is that if I walk into a florist and I'm gay and I want the florist to do my wedding, the florist will be protected under this law by saying, I don't work with you types.
You know, I think it's a really terrible misunderstanding because there have only been a handful of cases around the country under these state RFRAs that have even involved anything to do with gay rights. The vast majority of these cases have to do with religious organizations, especially minority faith groups, who are just trying to have their rights protected, like the Native American kindergarten student in Texas who just wanted to be able to wear his hair in a braid as his religion required to his public school.
Yeah, but he's got class protection. Laura, you know, come on, you're smart. You know this. You know where the critics come in. And Mark, I'll get you to weigh in on this as well, because one of the big debates has been that there's no class protection for the gay or lesbian couple that comes in and just wants to have a wedding.
And the problem, Lori is correct that there are only a handful of cases, but the problem is the way they set this up is when they have the legislative solution and they say we're prohibiting gay marriage, then you get a court that'll come in and the court will say no, you can't do that. And so this is the fallback position. This is their default position. This is precisely why Pence lined up the people behind him in that press conference to sign this law so that, okay, if we can't do it this way, we're going to do it another way. That's what they did. They're the ones who opened this up. This is part of the strategy. And to say, well, there's only been a handful of cases, well, that's fine, but they're now going to use this to challenge and to erode what they can't do legislatively or in the district courts.
Lori, I want to just tell our viewers, and if I can ask, I want to put a graphic up that compares the federal law with the Indiana law, because that's been a lot of the argument of the supporters of this bill, is that it's a mirror of what's already in place in the federal law. It doesn't seem like that's actually the case. In the federal law, it's designed to protect rituals or religious minorities. In the Indiana law, it's designed to protect the Christian businesses. And then look at this second nugget. In the federal law, the substantial burden to religious exercise is what they highlight there. But in the Indiana law, it's the burden or likely burden. I want to stop there only for a moment because I am very concerned about what a likely burden is. That seems so far-ranging that you get political cover for just about anything you want to do if you don't like gay people, period, and you don't want anything to do with them with your business.
Well, actually, I'm going to disagree, because actually, if you look at the Connecticut RFRA, which has been on the books for a number of years, they don't say substantial at all. They just say burden. And so we haven't seen the sky fall in Connecticut. I don't think the sky would fall in Indiana if they keep this language. What you have to do when you go to court is you have to show there's a burden, that it's really a serious one on your religious exercise. Showing something that it's likely in a legal sense in a legal case is actually pretty difficult. You think about the standard that it takes to win your case in court. You actually have to put a lot of evidence on.
Right, but Lori, what you've got here, the big distinction in Indiana is you've got Now it's business to business or business individuals. You've taken government out of the picture. And then the Arkansas law, which they're not talking about, went one step further. It also had a clause in it that proposed that the employer could impose restrictions or the burdens onto the employee.
I need to jump in only because I do have a lot of other breaking news today, but I also want to mention that Daniel Malloy, who's the governor of Connecticut, was on this, not on this broadcast, but the broadcast previous to mine yesterday, very, very critical of the Indiana law. I am not sure if there's class protection for gays and lesbians in Connecticut, but he's a Democratic governor. I will look into that, but he was absolutely and has actually stopped all state-sponsored funding to anybody in his state that needs to go.
That's why they're not going to the NCAA.
It just shows what a huge misunderstanding there is about what this law is and what it does. Getting back to Mark's point about the private
sadly,
businesses.
I cannot. But I want to have you back on because I think you're very articulate when it comes to this issue, and frankly, we need a lot more minds on both sides of this to really hash it out and get people to understand what the implications are. Lori Windham, thanks. Will you come back?
Thank you.
Thank you so much. Mark Geragos, as always, it's great to have you.